Appeals of Tennessee is now in session.
Thank you, Mr. Hibner, and thank you to all three counsel for participating in this oral argument via live streaming YouTube and Zoom meeting protocols. Please understand that we will conduct the oral argument today in the same fashion as if all of us were in the courtroom together. And of course, the appellant has 15 minutes and has elected to reserve 5 of that for rebuttal. And the appellees have elected to share their time, and they've agreed to divide 10 and 5 minutes separately, and we'll gladly recognize that. Let me add that this court is always conscious of the fact that minors' names and the ability to connect the dots to reveal who the minors are should be held in confidence if at all possible. And so instead of referring to the parents or the adoptive petitioners as by their last name, please just refer to them in the capacity of the mother or the appellant or the guardian ad litem, words of that nature. If something slips, we understand these things happen, but please be prudent in the choice of your words. Unless there are any announcements, Mr. Hibner, please call the case.
In Re Rommie H.
All right, thank you very much, and let's hear from the appellant.
All right, Your Honors, my name is Shay Forgety. I'm with the Sumner County Bar. I represent the appellant mother in this matter. Our position in this is that the court erred in terminating the mother's parental rights because the petition to terminate her parental rights didn't correctly plead the grounds relied upon by the court or grounds at all. There was no reference to TCA 36-1, 113G, 1 through 15. The court
there was a reference, however, to 37 as opposed to 36. Isn't that correct?
Yes, Your Honor. It was 37-1, 113.
Right. The only error or omission was that it was 37 versus 36.
Correct. There was no G after it or 1 through 15.
But there was a reference to a statute, the wrong number. One number was incorrect, but the grounds were clearly stated, weren't they?
Well, the grounds prior to July 1st of 2018, Your Honor. As you're aware, I'm sure the First and Adoption Act in 2018 changed the language of some of the grounds for termination of parental rights.
But can it fairly be argued that your client and her counsel were uninformed of what this petition was all about?
Well, I mean, uninformed that it was, no, we could not. I mean, it obviously states it's a petition for termination of parental rights.
Thank you. All right.
Moving forward, the petition stated that there was a willful failure to support. That it wasn't pled as TCA 36-1 and 113G, whatever the ground is. It just said willful failure to support. As I just stated, the term willful had been removed from the statute July 1st, 2018. This petition was filed July 31st of 2018, 30 days later. The court.
So are you suggesting your client was misled then by that pleading not to raise willfulness as an affirmative defense? Is that what you're arguing?
Yes, Your Honor. We didn't know which version of that ground we were proceeding under. Was it the First and Adoption version or the pre-July 1st, 2018 version?
But here you never asked, I know you weren't counsel for the entire case, but no one ever asked, hey, let us amend our answer in this case so we can assert that as an affirmative defense.
No, I did not. And part of my rationale for that was that the 4 months preceding the filing of the petition would have been controlled possibly by the prior law. So it wasn't exactly clear to me which version we were proceeding under. Now, the court also made a finding that there was a willful failure to visit as well. Now, that wasn't pled in the complaint. There was an allegation of a failure to visit, but the court made findings of a willful failure to visit. The court also made findings that TCA 361113G14 applied when the language used in the petition mirrors exactly G9A4 and 5, which only applies to putative fathers. Now, I raised that issue at the beginning of the hearing, and Chancellor Oliver said that we were going to have the hearing and it would be determined at the end of it. I also would like to point out that I didn't try these issues by consent or implication. I objected at the very beginning of the trial that the grounds hadn't been correctly pled or weren't pled at all. And that's contained in the transcript, volume 1, page 6. You know, the biggest issue here is we didn't understand, you know, which version of the adoption termination statute we were proceeding under. Was it the pre-July 1st, 2018 version or the post-July 1st, 2018 version? Because language, and there were other substantive changes as well within it. So, you know, how do you prepare a defense when it's, you know, the prior version of the statute's what's pled, but when the court asks which version of the statute is to be applied, it's not the one that was pled. So I did put in my answer what I would argue is an affirmative defense, even though reading the complaint, the language of it very closely or was identical to the pre-July 1st, 2018 version. Now,
did you ask for a more specific statement at any time of what was being pled?
Do you mean prior to the final hearing or at the
Yes.
final? No, I did not. You know, it was so close in time when the petition was filed to when the law changed that I don't think it really occurred to me until I was getting ready for the trial that, you know, they had pled one thing, the law had changed, but because the 4 months preceding were in the time period before the law changed, I wasn't sure that that wasn't what we were proceeding under.
Aren't there several cases that say the statute in effect when the petition is filed will be the one that controls?
Well, yes, there are, Your Honor, but I think what you're getting at is if it deals with a procedural issue versus a issue that affects substantive right. And
well, that and the fact that cases literally say that.
Right, yes, they do. I'm sorry.
That's all right.
Answered that more clearly. But, you know, it's our position that it did affect a substantive right, or, you know, because it affected her parental rights, obviously, and the termination thereof. And it just wasn't clear to us which version of the statute we were going under. And it was brought up at the end of the trial. The judge asked opposing counsel which version applied, and it was said that it was the post July 1st version, but that wasn't what was in the pleading, which further added to the confusion. And, you know, Judge Oliver in his order said that there had been a willful failure to support. Well, if we were, you know, proceeding under the First and Adoption Act, the word willful doesn't even appear anymore. It's just a failure to support.
Well, it appears in the fact that the parent may assert it as an affirmative defense.
Well, correct. Yes, Your Honor. But it did remove the term willful from the ground, and it shifted the burden onto the parent.
It removed that element from the petitioner's burden of proof.
Correct, and shifted the burden onto the respondent to prove lack of willfulness. But that wasn't, and it's our position, that wasn't what was pled in the petition. So the court couldn't make that finding because it wasn't pled. Same thing with the willful failure to visit. That wasn't pled. The court made a finding there was a willful failure to visit, but that's not in the petition for termination and adoption. The word willful does not appear with respect to visitation. And case law says that the court can only make findings consistent with what's pled in the petition for termination and adoption. So how can the court make a finding based on something that wasn't pled? That's my position. And I'll conclude my argument a minute early.
Very good. Thank you, Mr. Forgedy. We will now hear from the appellees.
Good morning. Patty Garner from the Sumner County Bar on behalf of the appellees. And just for the court's information, my clients are present in the room with me.
Very good.
Wanted to bring to the court's attention just one correction before I get started. Mr. Forgedy was counsel of record for the mother for the entirety of the case. He changed from being privately paid to being court appointed at some juncture late in the matter, but he was the only attorney that represented mother. He is the attorney that filed the answer to the petition that was filed, and he failed to seek a more definite or specific statement. With regard to his allegation of the typo that cited the code 37 versus 36, there's no question there was a typo in the petition, but there's also no question that the petition went further to state specifically that there had been a failure to support or a failure to visit. In the testimony that was given by the mother, she acknowledged that the custodians had not interfered with her attempts to have contact. So the limited contact that she had had, she didn't blame anybody except herself in her own testimony. So to shift the burden or to rely upon the fact that they're saying now willful was written in the petition and therefore they should not be bound by this finding, the fact that the law changed should have been sufficient to put counsel on notice that that was his burden to prove. The petition was actually drafted prior to the law changing, which is the reason the willful language is in there. We held it because we knew that the law was changing, and it is difficult to prove willful, as you know, because y'all are very esteemed and have sat on this bench for a number of years. It is difficult to put that burden on the petitioners in a TPR case because it's real easy for a mother or a father to simply say, well, I don't have any evidence that I paid or that I had the ability and I'm not providing it. And then that falls short. That's the reason that the statute was changed, that was created to protect children in cases just like this. But for counsel to come in and argue that he didn't know which statute we were traveling under, the court, Judge Clement, you're exactly right. The case law says whatever's in effect at the time of filing is what we're traveling under, which is exactly the response that I made to the trial court when we tried our case. The July 1.
That's true, but admittedly, a typo is one thing, but stating the elements incorrectly really cannot be condoned. But I understand your point that it'd be difficult to surprise the opposing counsel.
Yes. And for him to say he didn't understand, he never asked for clarification. the fact was that she didn't support, she didn't visit, she didn't argue that it wasn't her fault. So for now to come before the court seems disingenuous. There were multiple grounds that were sought in the petition. There were 3 grounds that the court found were appropriate to terminate her parental rights. At the time that we tried the case, she wasn't in a position to assume the child. We believe that the court made the right decision. I'm happy to answer questions, but we believe the court made the right decision, as evidenced by the brief.
All right. I gather from that you concluded your argument, so we'll now hear from the guardian ad litem.
Good morning, Your Honors. Erin Stubbs of the Sumner County Bar, guardian ad litem for the minor child. I certainly join in the position of the appellees, the adoptive family for this minor child. And I would submit to the court that mother asserted an affirmative defense of a lack of willfulness in her answer to this petition, the grounds of which are abundantly clear, even though there is a typo. And I would submit to the court that the findings from Chancellor Oliver are abundantly clear and supported by the evidence. And his findings that mother had the ability to pay and chose not to do so, that her visitation was not impeded in any way, and that she chose not to do those things, could be interpreted as a finding that the affirmative defense of lack of willfulness failed, or alternatively, that he held the petitioners to a higher standard than they were required to prove, and that they still met that burden, Your Honors. I would submit to the court that the evidence was very, very clear, that the court absolutely got the findings as to the grounds correct and as to best interest. And I would submit that nothing has changed between the date of trial and as we sit here today to change the fact that termination of parental rights is in my client's best interest. And I'll reserve the rest of my time.
All right. Well, you will not have an opportunity to for rebuttal. You can have rebuttal, but we won't hear it.
Yes, Your Honors.
We'll go back to Mr. Forgedy for his rebuttal.
Yes, Your Honor. A few things I would like to address. The guardian ad litem made a point about there being an affirmative defense in the answer. That's not what Judge Oliver found. He said that no affirmative defense had been pled. I think that what was pled was sufficient to be an affirmative defense, and it sounds like the guardian ad litem agrees with that. The mother did have visitation with the child. She saw the child the month the petition was filed. She saw the child, I don't remember, there were more months she had seen the child than more months she had not. No question about that. The mother, yes, she was convicted of a crime. She spent 11 months in jail, got out, got a job. You know, she probably should have gone and filed a petition in juvenile court. She didn't have the means to do it, didn't know how to do it. Our position in this is that the way that the petition to terminate her parental rights was drafted, it was confusing. It wasn't just would appear confusing to me. It was also confusing to Judge Oliver, because he's asking which version of the ground for abandonment by failure to support were moving under at the end of the trial. He made a finding that there had been a willful failure to visit, even though that hadn't been pled. And also with respect to the grounds that are identical to TCA 113 G9 A4 and 5, that's what, and the record supports this, that we thought they had argued, and they even admitted as much that when they filed their petition, it had included the mother and the father. That's why they had put that language in there, was because there was a putative father. So from my perspective, I didn't think that was applicable to us, I thought it only applied to him. Now, the other things, okay, TCA 37 instead of 36, that may be a typo, but it was a typo that appeared multiple times in the petition, as well as, you know, incorrectly stating a ground as well by saying, putting the term willful in there. You know, it's difficult enough to prepare for one of these proceedings, knowing what, you know, you're going to have to defend against. It's practically impossible when you don't know if you're proceeding under, you know, an old version of the law or a new version of the law based on what was pled in the petition. And I'll conclude my argument with that.
All right. Well, we, Judge Bennett and Judge McBrayer and I appreciate your arguments this morning. We will take the case under advisement. Mr. Hibner, you may conclude the case.
This honorable court is now in recess until 1 p.m.